Hello and welcome to the big picture. In yet another landmark judgment, a 5-member bench of the Supreme Court has put the onus on the Prime Minister and the Chief Ministers as far as appointing ministers with criminal and corruption charges are concerned. The judgment, which refused to pass any specific directions or suggest changes in any of the laws of our constitution, however, set forth some kind of do's and don'ts to the Prime Minister and Chief Ministers. Incidentally, this judgment comes on a petition filed as far back as 2004 when Lalu Prasad Yadav and 3 other Bihar MPs were facing criminal charges were inducted into the UPA 1 government. The judgment, however, has assumed significance as even in the present government, there are ministers who are charge-sheeted in serious criminal cases. The question is, are these views of the Supreme Court bench implementable? We will discuss all this today with S.Y. Quraishi, former Chief Election Commissioner of India, K.N. Bhat, former Additional Solicitor General of India and a senior advocate in the Supreme Court, Anil Verma, head of the Association for Democratic Reforms, K. Sachidananda Murthy, resident editor, The Week, and Vinod Sharma, political editor of the Hindustan Times. Welcome to all of you. Mr. Bhat, Mr. Bhat, I would like to come to you first. What do you see this as a judgment of the Supreme Court, a direction of the Supreme Court? What is this? Mr. Bhat? Mr. Quraishi? Can you hear me?
Ji, I can hear you.
Okay.
Yes.
How do you see this order or judgment or what direction or what do you think this is?
I think it's a very intelligent, polite nudge to the government, pointing out that this is something which needs to be addressed. And unfortunately, the reforms, electoral reforms have been coming in the past from the Supreme Court. And in this case, Supreme Court has given a very good opportunity to the government to correct something which has been agitating the minds of the people. And I think it should be taken as an opportunity by the government rather than as a threat or intrusion into their domain.
Mr. Bhat, can you hear me now? I think there's still an audio problem. Anil Verma, how do you look at it? You know, you people have been doing a lot of work on this whole thing. Recently also you have come out with studies about the present lot of MPs who have been elected in 2014. So, you know, when you look at that, at your work which you have done and what the Supreme Court has said, do you see any match there? Do you see anything which can be done?
So far, whatever actions have been taken have been sort of forced upon the political parties by the various Supreme Court judgments, and especially 2013 has been a landmark year. There are some very significant judgments which the Supreme Court has given. But notwithstanding that, we had welcomed the statement of the Prime Minister, and even on the floor of the House he said that he wants a taint-free government.
Yes.
But he had put the ball in the court of the Supreme Court. And the Supreme Court has now lobbed it back into the government, this thing, rightly so, because it is the prerogative of the Prime Ministers and the Chief Ministers to select their ministers.
Absolutely.
So if, as the ruling party, they have the maximum number of MPs in the BJP who have got a record of criminal cases against them, it is incumbent on the Prime Minister to take action. And we feel that this is extremely important judgment of the Supreme Court, and we expect that the Prime Minister should act upon it. And in today's newspaper I was reading, there has already been a news item which the government has put forward, that they are putting up a draft bill in which they are recommending that people should be banned in case they have charges framed against them.
They're thinking of amending the Representation
of People's Act. But the only thing in that is that they are saying not less than 7 years punishment, whereas the recommendation of the Election Commission, the Law Commission report, and even the civil society organization like ours, we have been saying 5 years.
5 years. Now, anyway, that is something which can be debated. Let me get Mr. Bhat in. Mr. Bhat, can you hear me now?
Yes, I
okay.
can.
Mr. Bhat, how do you see this?
I can.
Okay, how do you see this? What do you call this? Is it an order of the Supreme Court? Is it some kind of a direction? It's not. It doesn't look like a direction. What is it? Are they just laying down some do's and don'ts for the prime ministers and chief ministers?
No, it is the most decent way of telling that there is nothing we can do. The judiciary is telling the world that they can do nothing. That is all. Because the reason is simple. The qualifications and disqualifications for being members of the legislature have been laid down in the Constitution and the laws. The Supreme Court can't add to them. And once somebody is a MP, he is entitled to become a minister, and undoubtedly it is up to the Prime Minister or the Chief Minister to pick up whomever he likes. And picking up the minister is always on the basis of the political convenience.
Right. Okay.
It is not on the basis whether he is a good man or a bad man.
That is where the problem lies, and that's why this debate actually asks that question, whether how implementable something like this is. Sachi,
yeah.
It is what Anil Verma was pointing out. It's very interesting. There was, on 11th of June 2014, the Prime Minister in the Rajya Sabha made this very interesting statement that, and as Anil Verma was pointing out, he had put the ball in the court of the judiciary when he had said, and I'll quote, his speech in the Rajya Sabha, the Prime Ministers. He said that, the guilty should go to jail and the innocent should be able to stand before the world taint-free. There are so many politically motivated cases that are registered and many innocent people get tangled in them. We should be able to tell the country and the world that at least by the year 2015, we will see such houses, whether it's Lok Sabha or Rajya Sabha, where there is no sitting MP with any criminal cases. So how is this going to be done? He says that we request the Supreme Court that if there are any members of Parliament upon whom an FIR is lodged through the judicial mechanism, the cases should be expedited, and within a year the situation should become very clear. So as Verma was pointing out, it is the court, and Mr. Bhat is saying that it's a very decent way of saying it has lobbed the ball back into the Prime Minister's and the Chief Minister's court.
Yeah, I think Girish, Chief Justice of India, who had headed this bench, but he didn't write this judgment, it was another judge who wrote the judgment. But Chief Justice in another context had said, no, we cannot decide the cases pertaining to a certain category of people very fast while ignoring the cases pending against others. He said, we can't give you a special status, unless, of course, we have special courts constituted to try certain category of cases, but not certain category of criminals, or those who have been charged criminally. Secondly, this judgment, Girish, I have another basic worry about this. One of the judgments, concurring but separate judgment, says that once a judge frames charges against a person, that means a judicial mind has been applied.
Right.
So there is a certain thing that he has a criminal charge, and he is almost a what do you call a semi-criminal.
Yes.
He's a semi-convicted person. I don't agree with that, because our constitution's basic premise, and even the Supreme Court cannot tamper with that.
I'll just just two sentences of that judgment which you are mentioning. Yeah. Is there not the judge is asking in his judgment, is there not a cloud on his innocence at that stage, the charge-sheeted stage? Is it not a stage where his integrity is questioned? If so, is it not a stage where the person has come in conflict with law? And if so, is it desirable in a country governed by rule of law to entrust the executive power with such a person who is already in conflict with law? This is the...
Yeah, I agree. But then our basic principle of our judicial system is that a person is until proved. And then here,
they mention that also.
When charges are framed, the judge say, whoever magistrate does not hear the accused. The accused is heard only when a full trial takes, and a fair trial is an essential given by our constitution to every citizen.
Okay.
So I think we have to look at this, that a person charged with however heinous crime, until he is proven guilty by a court, but like that, no, the court has also said the Prime Minister and Chief Minister. We have Chief Ministers who are against whom charges have been framed. So how do we deal with that? We have Prime Ministers too.
I think it's an... Apart from the technicality, the legality of it, the practicality of the whole situation.
You see, first of all, it's an advice by the Supreme Court to the Prime Minister and the Chief Ministers. This judgment doesn't have a binding effect. And I think that the political class must be very happy about it, that it doesn't have a binding effect. Because even the present government is on the side, or on the defaulting side,
yes,
on this issue already. And let us not take names here. Secondly, I quite agree with Sachi when he says that, my right to judicial redressal is my fundamental right. And, in order to ensure that I get justice, there are three tiers of, judicial process that are available to a citizen of India. And until I am finally held guilty and convicted for an offence, I am presumed to be innocent. I have seen n number of cases where charge sheets are based on manipulated data. May I point out that on the very day that this government took office, all the accused in the Akshardham case were let off by the Supreme Court.
Right.
The same very Supreme Court which has given this judgment today.
We know there is a more important case, and very significant case involving a politician who had to quit, Shibu Soren. Shibu Soren was charged and convicted in that Shashinath Jha murder case, and later he was acquitted.
Yes.
He went out of the cabinet, he was forced out of the cabinet. Later in that case he was acquitted.
In this case, the person, if he is acquitted after having been denied the ministerial position, it makes the punishment irreversible.
Exactly.
And I would like to know from people like Bhat and Mr. Quraishi as to what extent is that justice to a common citizen who is seeking justice from the courts. This whole debate of fighting corruption, in my view,
and criminalization
is more of a debate that plays to the gallery rather than addressing the issue in any robust manner. I agree that the Supreme Court has taken a number of steps. They said they made them MPs declare their assets, and they've also said that if they make any false statement on affidavit, they would be disqualified. Similarly, there is this move towards quick disposal of cases. In
the case of corruption cases and all, they have said in 3 months.
So this is all fine. This is all fine. But to say that a person, I can be a member of parliament, as Mr. Bhat just now said, but I can't be a minister. What is the distinction between a minister and a member of parliament insofar as lawmaking is concerned?
Absolutely. Let me get Mr. Quraishi in on this, because Mr. Quraishi has been campaigning even as Chief Election Commissioner and later also. Mr. Quraishi, how do you answer these questions which have been raised?
Sure. Basically two questions were raised. One, that Supreme Court said that we can't have two different categories for fast-tracking court.
Right.
I would like to point out that that is possible. In fact, in a Representation of People Act for the last 65 years, we have a special category that election petition should be decided by the High Court within 6 months. Now, obviously, it's a separate category which has been created and has not been challenged. Therefore, creating a separate category of MPs and MLAs against whom cases are pending to be tried on an expeditious basis, I think it is legally possible. Second question which has been raised about the fundamental right. There I would like to point out that even I have often said that out of 4 lakh prisoners in jail, about 68% are still not convicted. They are still under trial. 2,68,000. And they are under trial, therefore still not convicted, therefore innocent. But you have taken away 4 of their fundamental rights. Liberty, freedom of movement, freedom of occupation, right to dignity. If fundamental right can be taken away of an under trial, still unconvicted, so where is the problem there? And finally, I would say that it is actually moral pressure on the political leadership. What stops them from not putting up such candidates? Fast tracking is the one the line of thought. The other is under, using your moral authority, not giving tickets to such people in the first place, and later on not making the ministers. That is, I think, very doable for the political leadership.
Okay, I mean that is the fundamental point why political parties give tickets to such people. In fact, the Prime Minister in that speech which he made in Rajya Sabha on 11th of June, he makes that point. He says that, I'm quoting him, we can make a beginning such as this in the world if we can clean up the Lok Sabha this way once. Then the political parties will also be compelled to think 50
Girish,
times.
Can I come in?
Yes.
Yeah, can I come in?
Yes.
Quickly. Also you will recall that in CVC PJ Thomas case, Supreme Court said that because there is a case pending against him. Now PJ Thomas was innocent in the sense because he had not been convicted. Why was he debarred? Why was he removed? So therefore Supreme Court itself laid down a principle of institutional integrity. Now here is a case, you can't become CEC if you are under trial, but you can become an MLA or minister if you are under trial, then you bring in fundamental rights. I think this distinction also has to be very clearly explained.
Okay, I mean that's an interesting point you made, Mr. Bhat. I'll come to you. Mr. Bhat, how do you react to this? This whole, the debate which has been going on in this country for years now, whether charge-sheeted people should first of all, be allowed to contest, at what level of charge sheeting, all this debate has been going on. Now it's all about ministers. Is there any justification?
Yeah, you see, you remember the original Representation of People's Act, which has been struck down in 2013,
right,
had the provision for appeal till the Supreme Court. Until then, the disqualification did not attach. The disqualification got postponed and the Supreme Court struck it down, telling that as soon as the conviction order is passed, disqualification comes into effect.
Right.
Now, I don't agree with Mr. Quraishi when he said that in the case of the CVC, different standard has been applied as regarding the MLAs and MPs. MLAs and MPs are the matter where there is a specific provision in the Constitution which says that who are all disqualified, and in the case of CVC, one observation was made that in the interest of the institutional integrity, this aspect has not been taken into consideration. That is how the Supreme Court put it. So in the case of MLAs and MPs, and to have them the fast track court, as Mr. Quraishi said, 6 months, within 6 months the election petition is to be tried, but nowhere
has it happened.
It has ever been achieved.
Absolutely.
So it never happens. The election petitions are generally concluded after the term of the MLA or the MP is over.
Sometimes 2 terms.
And no, it doesn't carry on this one, except where there is the corrupt practices alleged.
Sir,
when the disqualification is attached.
Mr. Bhat, this petition was filed on which the ruling has come yesterday. This was filed in 2004. It has come now 2014. 2 governments have gone, and now we have a third government in place.
Girish, I personally do not see the logic behind admitting such a petition at all, where the Supreme Court cannot give a relief, and it was known even in the beginning. It is not like challenging Lily Thomas case, challenging the provision of an act. It is just saying that, look, tainted ministers should not be there. Who is tainted and what is the taint? And we see very important people charged with very serious offences. But if the Prime Minister thinks that they are not guilty, they are good enough for the purpose of administration, so be it.
So be it.
That's what the Supreme Court has said. You decide.
Mr. Bhat, does it amount to giving judicial powers to the Prime Minister? That he will sit in judgment over who's guilty and who's not guilty?
No, it is not judicial.
Does it serve the basic objective of giving a clean governance, clean government?
No, it is not judicial power. You see, whatever the disqualification is there, it has been laid down in law. Supreme Court has not added any disqualification, nor can they add it.
Absolutely.
So, whatever is provided in the law,
Mr.
they have been enforcing.
Absolutely.
And then what is not in law, for example, Article 75 of the Constitution says that who can be a minister.
Right.
How can the Supreme Court add to it? Charge sheeted cannot be done, etc. These are all ideas for the lawmakers.
Okay, Mr. Verma.
Lawmakers to make new laws.
Okay, Mr. Bhat. Yes, Mr.
I just
Verma.
wanted to highlight the fact that where is the question of morality and ethics then? If we do not expect our lawmakers to be of utmost impeccable credentials
and integrity,
and you expect a peon also to give so many certificates of his character and all, where is the logic of fundamental rights versus morality and ethics?
May I add something?
Yes.
May I add something?
Yes.
Where is the guarantee? Where is the guarantee that the judiciary is wholly corruption free?
We are not discussing
the judiciary. It may be made against somebody.
No, I think the Law Commission and there has been some discussion about that. There has been some discussion about that in the Law Commission, and also this proposed amendments to the Representation of People Act. There have been discussions about that. Yes, Sachi.
As Mr. Bhat was saying, that this is only advice from the Supreme Court to the. But I would like to recall one Prime Minister who enunciated a principle on this. Mr. Vajpayee, when he became the Prime Minister in '98, within a few weeks of that, two of his cabinet ministers, charges were framed against them in corruption cases. One was Mr. Muthaiya belonging to the AIDMK, and there was Bhutta Singh who had won as an independent.
Right.
So, Mr. Vajpayee asked both of them to resign, saying that if there is a corruption case and charges are framed, I think they should stay out of the government. But he did not make the same thing regarding other criminal cases. But then he made a beginning saying that, so this is definitely this judgment, the Prime Minister and the Chief Ministers must think, but also the President and Governors must think when they appoint people as Prime Minister and Chief Minister. What did they have attained?
Vinod? No, for instance, Kalyan Singh, as has been pointed out by the Janata Dal United, he was in contempt of the Supreme Court and he's made a governor.
Yes.
Now, he's been appointed the governor by the same government of whom the Supreme Court is expecting not to appoint ministers who are tainted. So, I think that, in the kind of society, in the kind of polity that we live, this whole debate over fighting corruption is leading up to nowhere, because whoever is in power. Now see the number of cases which have been withdrawn against people after the advent of the new government.
Yes.
I mean, every government is withdrawn.
Every government is doing
so, and the Supreme Court at the same time, I think that Mr. Bhat is so right that Supreme Court is, almost behaving like, a damsel in distress, lost in the woods,
Mr. Quraishi, there is a certain amount of helplessness to this debate. Every time something like this happens, the Supreme Court comes out with something like this, or there is any other debate, there is a certain amount of helplessness. You think that, this latest move by the government to amend the Representation of People's Act and bring in certain amount of restrictions would help in certain, at least in certain cases, and, remove this helplessness which we all feel.
Yes, of course. Like Mr. Bhat pointed out, and the speakers also, that ultimately the political executive has all the power if they have the political will. It is for them to amend the act, and the system needs to be cleaned. Today is the time when the reputation of the political class as a whole is very, very low, which is very dangerous for democracy. Democracy requires the trust in politicians, and actually we have good political leaders. They have taken us to the great heights, but because of some bad eggs, the whole class is getting a bad reputation, and whose job is it to clean the image? And it is possible, and that is what Supreme Court has also said, that please bring the act. Bring the act at the root itself, that let them not be given tickets. Now, that could be done by political will. Don't give them ticket, law or no law. Second is, let them bring a law that people, and here also, this debate gets confused when people say that they are politically motivated cases. For the last 20 years, we have explained, Law Commission, various fora have explained that we are conscious of the politically motivated cases. We are only talking of heinous offences like murder, dacoity, kidnapping,
corruption,
and moral turpitude, for which there is a punishment of 5 years or more, corruption. So at least isolate them, and only those should be fit for disqualification. Others can be ignored as potentially politically motivated. So, and that number is not very large actually. You know, people say that 183 or 184 MPs have criminal record. But I think only there are 30-35 against whom the serious cases of the kind I mentioned are pending. So dealing with a small number is doable.
53.
Even in special court for such people is doable.
Yeah, okay. In fact, Mr. Verma, this is your ADR report, only the 53. The present Lok Sabha has 53 members with serious, serious charges of criminal charges and corruption against them. 53.
Yeah, those who come under the Supreme Court judgment of March this year, wherein it said that, people, so this is specifically RPA section 8, 1, 2 and 3 subsections.
So there are 53 MPs in this. So if you keep those 53 MPs out of them, how many are from the ruling party? Because they are the ones who can become ministers.
One minister.
There is one minister who is in the ruling party who is facing these kind of charges. That's not too much, when you actually break it down to think. Mr. Bhat, very quickly, you think that at some point of time the judiciary should take responsibility and do something about this instead of passing this on to the legislature?
Certainly not. I wish they stick to the law as made, and they don't lay down new law. Don't expect the judiciary to take over that responsibility. That will be dangerous.
Okay, as you said, they should not
lawmakers must make law.
As you said, the judiciary should not even admit this kind of petitions. That is what your view was earlier, actually.
Yes, I'm surprised that why this petition was admitted.
Okay, Sachi and Vinod, both quickly, last words. I mean, you both have been covering politics. You have seen formations of ministries and things like that. What kind of pressures come into play when every ministry is formed, whether the state at the national level? You think any of this will have any impact at all? All these do's and don'ts will have any impact now or in the near future?
So, Girish, in extreme coalition circumstances, is not possible. But where there is a strong leader, a strong Prime Minister or Chief Minister, they can definitely make a difference, saying that no, I will not take somebody. But then also it depends on you have to leave it to, as the Supreme Court has said, to the wisdom of that Prime Minister, whether he personally thinks that Ramvilas Paswan is corrupt or not. I'm just giving a name. So that's what the Constitution says, that judgment will have to be made by the Prime Minister. So that means we have to keep electing good Prime Ministers. That is important.
And Chief Ministers.
Well, in our kind of electoral politics, that kind of cherry picking is not possible. We'll have Prime Ministers who would be children of destiny, with great luck, riding great luck. But the fact remains that we have ceased to produce leaders who can set a personal example and not have a cabinet with any tainted minister. The reality of Indian polity is that Indian polity is hand in glove with all kind of shenanigans of other people, and it is jo jeeta wahi Sikandar. That's the sentiment which guides. That's the sentiment which guides. It's unfortunate, but it guides.
Absolutely. And I just want to end this program with one sentence of what the Supreme Court has said in this judgment. It says the great constitutional trust reposed in the Prime Minister, who enjoyed a great magnitude of constitutional power, cast a huge responsibility in him to maintain the sanctity of the trust. Well, they have said what they have to say. We will have to wait and watch how the political class will react to this, and whether they will take these do's and don'ts as something which has some sanctity. We'll wait and watch. Thanks to all my guests, Mr. K. N. Bhat, S.Y. Quraishi, Anil, Verma, Sachidananda, Murthy and Vinod Sharma. Please keep watching. We'll come back with another issue in Big Picture same time tomorrow.